Okay, good evening everyone, and welcome to our community session, which will help our community prepare for the upcoming public review of the Environment Effects Statement EES process for the Western Victoria Transmission Network project. My name is Catherine. I'm the Major Developments Community Engagement Officer at Moorabool Shire Council, and I will be moderating today's session. Before we begin, I would like to acknowledge the traditional owners of the lands that make up Moorabool Shire, the Wadawurrung, Wurundjeri and Dja Dja Wurrung peoples, and pay my respects to their elders past, present and emerging. To reach as many people as possible, we are holding this session virtually from our own home, so please bear with us if any technical difficulties come up. Our hope is that this session will empower our community members and provide valuable information. We'll begin this session with presentations by each of our expert guests, Louise Hicks and Jack Crone, that address many of the questions we've received from the community in the lead up to this session. After that, we'll have the opportunity for live Q&A with those of you who are tuned in. Your microphones are muted, but you can submit your questions via the question box on the right-hand side of your screen. We'll try to address as many of these questions as possible, but please keep them relevant to the topic of the session, or unfortunately we won't be able to answer. Okay, let's get to it. I'm delighted to welcome Louise Hicks, barrister, and Jack Crone, Senior Impact Assessor at the Department of Environment, Land, Water and Planning, and we'll have Jack speaking first.
Thank you very much, Catherine, and thank you for the opportunity to speak to you tonight. I'll be talking about the public review phase. It will be a bit dry, and I'm sorry about that, but I'll try and make it as interesting as possible. I'd like to start also by acknowledging the traditional owners of the lands across which we are meeting. In my case, it's the Wurundjeri people of the Kulin Nations, and pay my respects to elders past, present and emerging, and any other elders or members of traditional owner groups who may be present with us tonight. So if I could flick on to the next slide, please, Catherine. This is a slide that those who have come to these sessions before will have seen before, or at least a version of it. It's a very simple flowchart of the EES process, and the public review phase that's in red there is the phase that I'll be talking about tonight. I should stress that we aren't in that phase yet, and we've got a little way to go before we get there. We're still in the phase where the EES is being prepared. So we are, in a sense, getting ahead of ourselves tonight, but this is by way of demystifying what is yet to come at the point where that happens. So if we could go to the next one, please, Catherine. The public review of the EES starts after the proponent believes they've got to the point where they have a complete draft of the Environment Effects Statement, and they at that point submit that to the Minister and ask the Minister for authorisation to exhibit. If the Minister is satisfied that the EES as drafted is adequate or can be adequate with minor corrections or improvements, it is then, the jargon that we use is exhibited, it is published, and people can make comments on it within a set period. It's open to anybody to make a submission. If the project in question requires statutory approvals, and they almost always do, as far as possible, the procedural requirements for those statutory approvals are coordinated with the EES. The Minister appoints an inquiry to review the submissions and the EES and conduct hearings. When the inquiry reports to the Minister and the Minister has made his assessment, then the Minister's assessment and the inquiry's report are published. So if we could go on to the next one, please. So the first big step in there is what we call authorization for exhibition. So this is about the way that the EES responds to the requirements that apply to all EESs. The Environment Effects Act is very brief, and it doesn't really specify requirements for an EES, except that it places the responsibility for preparing the EES on the proponent. But at the authorization stage, we're not looking at the merits of the content of the EES in terms of how good a case it makes in favour of the project. That's not part of our consideration at that point. It's coming back to whether this is an adequate package of information that interested parties in the community, be they decision makers, landowners, stakeholders, or environment groups, or whoever they may be, is this an adequate basis of information for people to form views and prepare submissions? I've referred on other occasions to the ministerial guidelines, which is that document that you can see and look at on our website, which is about a 30-page document that puts shape around the process for EESs, that is builds on the very limited, very framework basis in the actual act. And as I'm sure you know, the Minister issues scoping requirements for each environment effects statement, which go into a fair degree of detail about the questions that the EES needs to investigate and respond to. So we're looking at the final draft EES in terms of its consistency with the ministerial guidelines, the way in which it responds to the scoping requirements, the responses that the proponent and the proponent's consultant team have made to comments from the technical reference group on drafts of the technical studies that are the building blocks for the EES, and in cases where peer reviews have been appointed either by the proponent or by the department, the way in which those studies respond to the advice from the peer reviewers. Ultimately, the proponent is responsible for the EES. The proponent is responsible for its content and its quality, and will have to defend, if you like, the arguments that it presents, or the analysis and assessments that it presents in response to whatever people may choose to say in submissions. So I stress that authorisation is not in any sense either the department or the minister expressing a view about whether the project is a good project, whether the project is the right project. It's simply about whether this is an adequate response to those contextual requirements to say, yes, this should go out and people should be given the opportunity to comment on it. So if we could go to the next one, please, Catherine. And this is where we talk about the actual exhibition submission process. The ministerial guidelines say an EES will usually be exhibited for a period of 20 to 30 business days. In his decision, at the time of his decision to require the EES, which was back in August of 2020, the minister specified an exhibition period for this EES, of 30 business days. That may be reviewed at his discretion. Normally, if the minister is on the occasions where the minister has chosen to change the required exhibition period, that is made quite close to the point where the EES is ready for exhibition, so that the decision is made both in the context of circumstances applying at the time and in the context of a sound understanding of the nature and magnitude of the EES itself. The exhibited EES is a package. It will include, what, for want of a more original term, we call a main report, which is commonly 2 to 3 volumes if you look at it as a hard copy package. Technical appendices, which are the final reports of the various specialist consultants who have conducted investigations and written reports that the EES draws from. So all of the substance essentially ought to be in the main report, but if you really want to delve into the technical detail of where the noise consultants put their noise loggers, or where the quadrats were for the flora surveys or whatever, that information will be in the technical appendices. But for a person wishing to make a submission, they should be able to find all that they need in the main report. You may also wish to look at attachments. There is commonly, especially for projects that cover a broad geographical extent, there is commonly a map book. There may be a draft planning scheme amendment. In some cases, there may be draft applications for statutory approvals from EPA or other authorities. So those are usually branded as attachments. And there is also a brief non-technical summary document. It's usually got a fair bit of visual content in it. It's usually quite a short document, and that essentially explains what the project is and how the EES process has been applied, and it will include information about how you make a submission. Over recent years, the submission process has been sort of standardised through an online portal provided through the Engage Victoria platform. That platform's recently gone through a little bit of an upgrade, but I understand it's bedded down and working well. So that's the main way in which people can lodge a submission having looked at the EES. The value of that online portal is that it provides a number of sort of checkpoints where people can tick boxes to confirm that they understand the privacy arrangements, to make sure that people give an indication of whether they wish to be heard or not, and so forth. So that makes sure that Planning Panels Victoria, who administer the submission part of the process, can gather all the information they need to be able to administer it effectively. In lodging a submission, there is a text box that you can type your submission into, but there is also scope to attach other files as adjuncts or attachments to your submission. It's really important for that people who are concerned about the project and who may wish to be heard at the inquiry hearing, it's really important that they lodge a written submission, because if you have not lodged a written submission, you will not be invited to be heard at the hearing. So if we go to the next one, please. So the Environment Effects Act says that the Minister may appoint an inquiry with the approval of the Governor in Council. So that's some additional sort of administration that has to be done at the department end. An inquiry looks a lot like, if you're familiar with a Planning and Environment Act panel, it looks a lot like a panel, and it is in fact appointed through Planning Panels Victoria. That inquiry operates in accordance with terms of reference which the Minister will give it. And I guess I would, in terms of this stuff, I would really encourage people who are interested to have a look at the panels and committees page on the DELP website, and possibly also there's an opportunity at the moment, because there is an Environment Effects Act inquiry hearing in progress, to go to the Engage Victoria portal and have a look for Suburban Rail Loop East, and those hearings are being held online at present. They're probably not being held at 6:15 in the evening, but during the day they're on, and there's an opportunity then to have a look at things like the terms of reference for that inquiry, and to listen to the inquiry in progress to get a bit of a sense of how that operates. It's common these days that an inquiry under the Environment Effects Act is also appointed as an advisory committee under the Planning and Environment Act, and that particularly applies when there is a draft planning scheme amendment as an attachment to the EES. And our understanding for the Western Victoria Transmission Network project is that that's likely to be the case for this project and this EES. So if there's a draft planning scheme amendment, appointment of the inquiry as an advisory committee can then ask it to provide the minister with sort of technical planning advice about the planning scheme amendment as well as the broader environmental effects of the project. So the inquiry will review the EES. The inquiry may be made up of several members who are appointed on the basis of their range of technical skills and expertise and experience, and between them they will read the EES and they will read the submissions. They will hold a directions hearing. That's usually 3 to 4 weeks after the close of submissions, and that gives them time to get their heads around the substance of the submissions. In most of these cases, the bulk of submissions arrive very close to the closing date, so they can't be read until they arrive. The public hearing then starts 3 to 4 weeks after the directions hearing, and that gives time for those parties to whom the inquiry has given directions to respond to those directions. The inquiry will generally distinguish between submitters and advocates and witnesses, and will manage cross-examination of witnesses, and I'll probably leave Louise to talk about that. That's her territory more than mine. The inquiry will also issue a detailed timetable, taking account of the times that people who wish to be heard have asked for. Not everybody will necessarily get as much time as they might ask for, but the purpose of the timetable is to make sure that everybody knows what's on when. However, that may well be revised, and it's common for the timetable to go through several iterations according to things taking longer than anticipated, or parties making a later decision not to be heard or to combine their time with another party or whatever. The hearing arrangements are determined by the inquiry chair. At the moment, inquiry hearings are happening online. That may continue to be the case. They may revert to face-to-face hearings. They may adopt some sort of hybrid. We don't know. That will be for the inquiry chair to settle those and any other arrangements. In recent times, EES hearings for major projects have taken several weeks, and that may well be the case this time, but the duration of the hearing is essentially a function of the range of issues raised in submissions that the proponent has to respond to, and the number of submitters who wish to be heard. So if we could go on to the next one, which I think is the last one, Catherine. So when the inquiry hearing has finished, the inquiry sits down and writes a detailed report. Its terms of reference will give it a time frame for that report, but it's usually something in the vicinity of 6 to 8 weeks after the end of the public hearing. So it delivers its report to the minister. The minister considers that report along with the EES and submissions and issues the minister's assessment, which is the final output of the EES process. And the focus of the minister's assessment is on those two questions: are the environmental effects of the project acceptable, and are modifications to the project required to achieve an acceptable outcome? There will be a lot more detail than that, but those are the crux of what the minister's assessment needs to deal with. The minister's assessment is provided directly to the proponent and to statutory decision makers, and is subsequently published on the DELP website along with the report of the inquiry. Under the ministerial guidelines, the minister's assessment is normally provided within 25 business days of the minister receiving the inquiry's report, and we work quite hard to enable the minister to be able to meet that timeline. And under the Environment Effects Act, decision makers are required to consider the minister's assessment. So the minister's assessment is a package of authoritative advice. It's not executive, and it doesn't constitute a decision, and it doesn't bind decision makers. But having said that, the experience over the 40+ years that the Act has been operating, and throughout that time, the Act has set out and provided for an assessment which decision makers must consider. I can't recall an occasion where a decision maker has made a major decision that is diametrically contrary to the minister's assessment. So that's probably it from me, Catherine. I'm happy to hand over to Louise and then deal with questions that come up after that. So thank you.
Thank you, Jack. That was wonderful. And now to dovetail very nicely with the summary that Jack has provided, we have Barrister Louise Hicks to talk about the submission and participation for the EES from her extensive experience. So over to you, Louise.
Oh, thank you very much indeed, Catherine, and for that warm welcome, and thank you, Jack, for your presentation. This evening I'll be touching upon the pointy end, being the process, once you're actually in the process, how you get in the process, how you stay in the process for as long as you want to, and what you can do when you're in the process. We may be many months away from when you will have the opportunity to be actively involved in this process, but it is a good idea, in my view, to start thinking about what the steps might be, what you'd be comfortable with getting yourself involved with, and you can always return and have another look at this presentation later on as you get closer to the dates when you might need to be doing some of the process things like the cross-examination that I'll touch upon today. And so first slide, please, Catherine. So the structure of my presentation tonight will be looking at the submission, some drafting tips about how to make your submission as effective as possible. And from writing many a submission in my day, I've learned what works, what doesn't work, what's persuasive, and what's not persuasive. So I'll try and impart some of those tips to you. I'll then be delving into some of the, in some way, perhaps a minutiae of the process, looking at the directions hearing. Why should you attend it? What does it do? What happens at it? And then moving on to the hearing, what happens at it? And we'll look a little bit around, now you've made your beautiful, comprehensive, persuasive submission, what you can do in terms of cross-examination. Now, before I embark upon this, I must make it clear, and I'll say it again when we get to the cross-examination bit, if you are an advocate, like I would be if I went in as a barrister, or if you're a submitter, you're not a witness, and that's an important distinction. So you don't need to worry that in putting in a submission, you'll have cheeky people like me cross-examining you on your submission. So an individual submitter doesn't get cross-examined. So you can take that off the list of things to worry about. Next slide, please, Catherine. All right, so first task of this evening, submissions. First thing to note about submissions, and Jack has touched upon this, is submissions. When you go through that Engage portal, you'll get the question about privacy. Bottom line, submissions, they're all public. They're all public documents. So bear that in mind when you're drafting. Because anything you say, anything you show, there's a question about whether you can attach videos. Yes, you can. I'll come back to that when we get to the hearing section. But anything you put in there by way of submission, it's all public, and that might have a bearing on how you express the points that you want to express. Focus in straight away when you're thinking about putting pen to paper. What I always do is I get the terms of reference out. Because what I found through bitter experience is that the submissions I made that were not persuasive were ones where the committee, the advisory committee, the panel, the inquiry was able to say, well, Miss Hicks, that's got nothing to do with our terms of reference. So I learned very quickly that the core of the submission, Jack's point about, has to be relevant to the nature of the inquiry. You get that from the terms of reference. What is it that the inquiry has been asked to do? So keep that by your side as you're drafting your submission. Same with the scope of the EES. So often when we approach questions of environmental assessment or planning scheme amendments, there's likely to be one associated with this particular EES. We tend to think that an EES or a planning scheme amendment can cure a whole variety of ills or concerns. And we might find, much to our disappointments, that in fact these tools are much more narrow in their focus. And so we need to be very clear, what's the scope of the task before the inquiry and the scope of the documents, being the EES and any associated planning scheme amendment that the inquiry is considering. The second thing is be very straight with the inquiry. Who are you? Who are you representing? Because we can spend an awful lot of time getting in a guddle, a right muddle at the directions hearing, trying to work out who's who and who are you representing? Who do you speak for? So if you're speaking for a bigger group or an organization, an incorporated organization, whatever it may be very clear in your submission who you are, who you're speaking for. And if you're speaking for others, make sure you've got their authority to do that. You might want to keep a list of who you're speaking for and get them to sign that list so that you're nice and secure about who you say you are and who you are speaking on behalf. Another bitterly learnt experience from my years of writing submissions. For goodness sake, be clear. A point isn't made, I think actually it was a judge that said this to me, a point isn't made any better by A, repetition, or B, trying to cloud it with all sorts of provisos and clever things. Just be clear. Be clear as to the point that you wish to make. A lesson bitterly learned. So just cut through all the nonsense and be clear on the point. You can often practically achieve that by, I know it sounds a bit silly, but keeping your submission with lots of headings. So the reader of your submission can go, oh, I see. So these paragraphs are going to deal with a particular subject. Then tell people very clearly what you say about those subjects. Be brief. Be brief. Again, points don't get any better, either from repetition or going on and on. You'll just lose your audience. Whatever you write, I was given this tip when I started at the bar, and it's one that's really stayed with me. As you write your opening submission, think about what you might want to say at the end. Because at the end of the EES process, if you want, and if the inquiry is feeling a little on the generous side, you might have the opportunity for a short, very short, right of reply. You might. It's not always granted, but think about what you might want to say at the end. That will inform your submission. It will help you be clear, it'll help you be brief, and it will also inform any cross-examination that you might wish to undertake, and we'll come to that later. Next slide, please, Catherine. So you put in your submission, you've ticked the box if you want to say, I want to be heard at the hearing. Make sure you tick that box if you do want to be heard. You might want to just preserve your position. If you decide later on you don't want to be heard, not to worry, they'll still read your submission. It'll still be taken into account. But if you think, maybe I do want to be heard, make sure you tick that box. Why would you attend the directions hearing? That's the next thing that happens, and it's in the lead up to the actual hearing. It's normally a shorter thing, about quickest ones, an hour and a half, may take the whole morning if people have a lot to talk about. It's procedural, but it's important to be there in my view, because you get a good idea of who's who. You get a good idea of the big ticket submissions that are in play, where you might want to say, oh, their submission's really interesting. I might want to join up with them. I might want to join forces, or say, look, I'm going to deal with whatever issue, cultural heritage, if you're going to deal with landscape, visual impact. So you might find ways of being really efficient in how you put your submissions together, and which points you press, put weight on, and perhaps you'll rely on others to make another point that you were otherwise going to make, because the inquiry is not going to want to hear points made twice, in as much as that can be rationally achieved. So I would say definitely attend the directions hearing. It really gives you a good introduction as to who's who, what points are in play, and you'll be asked some specific questions about how long you think you're going to take. Be as accurate as you can. Nothing drives an inquiry more berserk than people saying, oh, I only need 5 minutes, and then they take half an hour. Drives the inquiry nuts. So be as accurate as you think you possibly can be, and perhaps err on the side of putting a little bit more into your budget if you think that you might need a little bit more time. So don't feel rushed, but don't underestimate your time, because that will throw out the timetable and there'll be a lot of unhappiness as a result. You might find, depending on the nature of who's representing whom, if there are a few barristers involved, you might find that some barristers are saying, well, I want more detail about this particular submission, and you might be asked to provide some more detail. Don't be frightened of that in the directions process. You don't have to do it when you're sat there at the directions hearing. You can ask for a suitable amount of time to provide that further information. Next slide, please, Catherine. So we've gone to the directions hearing. We're now into the hearing proper. Now, as Jack indicated, these hearings can go for a very, very long time. And unless you're a professional engaged to be at it for a particular client, who has the time to be there the whole time? It's a huge commitment. So if you decide I can't be there for the whole time, I have a whole other life with a whole other set of things I've got to get done, there will be, through the Engage platform, a timetable that will set out who's going to be appearing on any particular day and which witnesses they'll be calling on any particular day. So you will be able to find out, right, I know when my submission is going to be, because that will be specifically stated in the timetable. And if it changes because people take too much time or too little time or whatever happens, you'll get a call from Planning Panels Victoria and they'll sort you out in that regard. So don't worry about that. That'll be in the timetable. If you also want to hear the submissions of others, they'll be in the timetable. If you want to cross-examine some of the witnesses, because only witnesses can be cross-examined, remember, not other submitters. Nobody's going to be asking you a question if you're a submitter, unless it's the inquiry and they want to know a little bit more, but not other parties or any smarty pants barristers. But if you want to ask some questions of the experts, then the timetable will tell you when they're going to be on. Keep an eye out though, the timetables change. So just keep checking in to Engage to see, oh, I thought traffic was tomorrow, or oh, I thought cultural heritage was the day after. It's changed. So keep an eye on that, and bear in mind that if you do want to ask any questions of the witnesses, you have to be there for the whole of that witness's presentation of their evidence. So you can't come in and say, oh, I wasn't here for what's called the evidence in chief. That's when they're giving their evidence, but I want to ask some questions now. The inquiry will shut you down and say, I'm sorry, you can't do that. You have to be here for the whole of that particular witness's evidence. When you're thinking about presenting, or you're thinking about whether to ask a question or not, have a think. If you have been able to be there for a bit of other people's presentations, and the inquiry will understand if you can't be there throughout. If you have had the opportunity to listen to somebody else, have they already answered a particular question that you might otherwise put? Have they made a point that you would otherwise make? In which case you might say, well, Mr. Blogg said such and such. I mean, you can be a bit fancy pants if you like and say, oh, I adopt what he said in that regard. Or you can just say, I agree. In other words, you don't need to make the point again. You can say, well, Mr. Blogg said it really well. I agree with what he said. It's in my written submission, but I won't talk to that anymore. So that's a matter for you if you want to try and be as efficient as you can. As I said, keep to time. Ooh, that's a real critical thing if you can. But if you find that you do need a little bit more time, be as clear as you can with the inquiry as early as you can, because it does cause a lot of angst if that doesn't happen. Another thing that drives the inquiries nuts, don't interrupt other submitters. I don't know if it's better or worse now we're all on Zoom. I think it's slightly better. Though be very careful about the use of your mic, because so often still people forget that they're on mic. And there have been some classic, truly classic statements made when people didn't realize that they were broadcast. But whatever you do, don't use that unmute and don't use that space bar to interrupt other submitters while they're submitting. You will meet a very unhappy reaction should you do that. I've talked about right of reply already. Next slide, please, Catherine. All right. I did say to Catherine and to Vanessa that, and to Jack, that I have the capacity to go on a bit about cross-examination because it is regrettably the part of my job that I really, really love. And I don't think that speaks well to me as a human being. But insofar as it might be of any use to you when you're preparing for the EES process, I will try and address that. Cross-examination is a useful tool, but is often done badly and is often overused. So make sure that your questions actually address your submission, that arise from your submission. What did I say in my submission that I want to bolster through some questions of the witnesses? Next slide, please, Catherine. One of the tips for cross-examination is think of the answer that you want, then put a question mark at the end of it. I know it sounds daft, but it actually works. So you're making a statement with a question at the end of it to see whether you can get an agreement about that. So that's a bit of a tip in terms of asking a question. What is it I want? What do I want them to agree with me about? And just put a question at the end of it. You might have heard the term leading questions. In cross-examination, go for it. The only thing you can't lead is your own witness. So say if you were bringing evidence yourself, you can't lead the witness by giving them the answer in the question. In cross-examination, that's exactly what you want to do. So lead away. One thing that I've seen go very wrong in cross-examination is where the questions aren't split up into separate propositions. So what people, normal people, by that I mean not legally trained people who are not burdened with all this nonsense, what normal people do when they're asking a question is that they engage in a conversation. Yes, it's what normal people do. It's not how you cross-examine. How you get the most out of a witness is by putting one simple, clear question at a time. Don't preface it with a lead up or a build up. Just ask a question, be straightforward about it, and ask one question at a time, because otherwise the inquiry will interrupt you and say, look, I don't know which question the witness is answering, because there were 3 propositions in there, so just one question at a time. Don't express a personal opinion. I'm afraid to say nobody cares about personal opinions. Simply ask a question. Don't make another submission, in other words. Thank you. Next slide, please, Catherine. The purpose of cross-examination, the purpose of asking questions of the witnesses is not to, well, this is really, for me, it's not to show off in front of your client. It's not to show off in front of the inquiry. It's to get some information from the witness that you think might help your submission or your case. Approach the question, because I've seen this done a lot, the question of, I'm going to discredit this witness. I'm going to, diminish their credibility. Approach it very, very carefully. Again, the inquiry will shut you down if you are bullying the witness or if you're being unnecessarily disrespectful. So I would approach any question of just trying to discredit the witness with a huge degree of caution. What's best to do is simply to put your side of the position. I've got a concern about this particular flora or fauna, this particular landscape impact, and seek their view. Keep it simple and don't try and be overly clever by seeking to discredit the witness. I often hear things like, oh, well, you've been hired by the proponent, so you are just adopting the proponent's position. The experts that you will hear from at the EES are all independent, which means that their primary duty is to the inquiry, not to the them's what paid them. And so you're entering into difficult ground if you seek to discredit the witness in that way. So I would avoid it if I were you. Next slide, please, Catherine. So when you're thinking about what questions you might want to ask, it's always best if you can to start with where you think the witness might actually agree with you, because it'll be helpful for the inquiry if they say, oh yes, I remember so-and-so said that in their submission. Oh, now they've put that clearly and briefly to the witness and oh, he's agreed or she's agreed with that proposition. That's helpful. So always start with where do I think I might get them to agree with me on certain things? What might they concede? And then go to, if you're feeling game, those areas where you think they're never going to concede that point. But you might think, no, it's too critical a point. I've got to put it to them and see what they've got to say, what might assist the inquiry. Next slide, please, Catherine. Now, if you are going to ask questions, you have to brace yourselves for smarty pants like me going, I object. I object to that question. Don't panic. If you get the objection, it's got to be put on a proper basis and the inquiry chair will look after you in that regard. You just can't object. And so if you do bring evidence yourself and somebody's asking questions, you too can't just object for any reason at all. I've put some bases upon which you can object on that slide. And so if you're met with an objection, don't panic. If you're a lay person, not a barrister, a solicitor, person of that kind, it's likely the inquiry will say, well, hang on a minute. What's the basis of that objection? So if you get one, don't panic. Let the inquiry look after you. They are likely to do that. And you'll be given an opportunity to respond. So if somebody says, oh, well, it's completely irrelevant or it's unfair to the witness, you'll have an opportunity to respond to that before you're either allowed to put that question or maybe more often the inquiry will say, let me have a go at asking this question. Is this what you meant? And that can be helpful anyway, because your question is nevertheless asked. Next question, please, Catherine. So some do's and don'ts. Firstly, I'll deal with improper questions and then I'll go for the 10 commandments, which I love. They're a good little catch-all. Don't try and mislead the witness. Don't try and confuse the witness. It's just trying to show off and it's never effective in matters of this kind. Don't try and intimidate the witness. It's a waste of your time. Don't try and annoy the witness. Don't enter into a conversation with the witness and certainly don't belittle or insult them. The next slide, please, Catherine. So in summary, and these tips, I think, are good for your submission writing as well, because they go back to those core points of brief, clear, plain, persuasive. For your questions and for your writing of the submissions, be brief. Make the questions short. Don't use fancy words. Be plain as you like. You know, I should be teaching this to barristers, really. Only ask leading questions. Remember the question mark at the end. If you can avoid it, because it'll get embarrassing, don't ask a question you don't already know the answer to, because they're going to bamboozle you with the answer. Don't argue with the witness. That's very important, because think back what I was saying about normal people and how they ask questions of each other or engage back and forth, back and forth. Yes, normal conversation. That's not what we're doing here. We're doing something completely different. This is not a conversation and it's not an argument either. I've put in do not allow the witness to explain. What I mean by that is, let me see if I can put this in language that isn't rude. If they're going on a bit and they've already said what they're saying, you're likely to have the inquiry step in and say that's no longer helpful. But you're also able to say, I'm so sorry to interrupt, but you're not actually answering my question. So do it politely. Don't let them go on and not be responsive to your question. They've got a duty to be responsive to your questions, to do you that respect. If you can, avoid the one question too many. The one question you think, oh, it's a burning question. I've got them. You get carried away with adrenaline when you're doing this part of the job. It can happen in submissions as well when you're giving a submission. Just be careful that you're not trying to do the conclusion question. Put that in your submissions. Last question, last slide, please, Catherine. Don't be disheartened, though. Can we go to the last one, please, my dear? which is opinion. That's it. Thank you. Don't be disheartened if you feel that you really haven't achieved very much in cross-examination of these experts. You will have if you've been brief and you've been clear and you've put your side of the position to them. It will be of assistance to the inquiry if you've done that. And that's, after all, what we're trying to do. Get our side of the story clearly put to the inquiry and give them as much information as we can through the questioning of the witnesses to support what we've said. The difficulty with opinion evidence is always you're dealing with people who have deep expertise in things that you might have some expertise in or some knowledge about, but it's always difficult. So never put a direct question to the witness. Well, look, you're wrong about this, this and this. Try and, if you can, with opinion evidence, I've described it as coming at it sideways. By that I mean, look at the assumptions that they've made in their expert reports. Is there something there that you might be able to attack? Inquire about how long they've spent on site, in the site and surrounds, looking at a particular issue. Is there anything that they haven't considered that you regard as critically important? Have they ever said something in another case, go on OSLI, if you like, OSLI is a nice little legal search tool, where they've said something different that you might be able to use here? Don't use it in a belittling or aggressive way, but it might be quite helpful. Oh, they've said something quite different in a circumstance quite similar to this. Is there something there? But be careful, don't accuse them of bias. That'll get you nowhere, and it again will be a source of embarrassment for you. I know that's a lot. I hope it's been helpful, and I look forward to your questions.
Thank you so much, Louise. That was great. Let me just pop over to our next slide. Okay. Q&A time. So we have had several questions that have come in advance, so we're going to move on to those now, and then we will go to any questions that have come up in the live Q&A that haven't already been answered in the presentation. We'll just check in anyway to make sure that they have. So a reminder that in order to maintain their professional objectivity, it won't be possible for Louise and Jack to provide advice on the specific circumstances of individuals affected by the Western Victoria Transmission Network project. However, any questions that you have will be answered from a process standpoint and, you know, that general sort of standpoint. So on that note, I'm going to start with the questions that we received in advance, and Louise and Jack are going to answer these in a sort of conversational style. So we'll just keep the holding slide up for now so that we're not hopping between video. So the first one that's come in is, how many pages should the submission be, and should we try to cover as much as possible?
Do you want me to have a go at that first, Jack? Yes.
Yes, I think it's,
yes.
It's mostly for you, this one.
Okay, so in terms of how many pages, that's going to be dictated by how persuasive you want to be. So think back to what I said about brief and clear. If you go, say, to the Court of Appeal, so you go upstairs and you're having to present a case there, they say no more than 9 pages. And I've always thought that's silly. That's I hope nobody from the Court of Appeal's listening. That's silly. I mean, it's just so arbitrary. But you see, they're just trying to make us think very clearly. So there is no page limit, neither minimum nor maximum. It's going to be guided by brevity and clarity. And think about, well, if it's good enough for the Court of Appeal, keep it short, keep it snappy. But having said that, the second part of the question, cover as much as possible. You want to put in your submission the points you're going to be raising. So you don't want the proponent saying, well, we've got all the way to the inquiry, and I'm now being met with a different point. I'm not prepared for that point. And I'm prejudiced, and there'll be all sorts of nonsense and carry on. So it's much better if you can. You don't need to go holus bolus into every single point, but in your submission, you need to make sure that you raise each category of point. The guiding principle is that people who will be responding to your submission need to know the case that they have to meet. By that, I mean they have to have some idea, oh, you're going to talk about visual impact on landscape. Okay, I need to be ready for that. So make sure that you cover off each topic, but it doesn't have to be to the full extent. You can, at the actual hearing, go to your submission and expand upon it as long as it relates still to the topics you've raised. There may be a bit of information that's appeared since you made your submission, or you've thought more deeply on a particular issue, so you can fill it out in the oral presentation of your submission. That's why you go to the inquiry, but you will have to have raised the particular subset of categories.
Yeah, the only thing I'd probably add there, and just from our perspective in terms of impact assessment, I think the most useful submissions in the process are the ones that come from people who care about the thing that they're making a submission about. So if you really care about a particular environmental issue, that's the best focus for your submission. Making a submission about a whole bunch of things that are not really in your area of concern is probably not going to be terribly effective or terribly helpful. It may well actually distract from the point that you're most concerned about.
Thank you, that's very helpful. So the next question is, when AusNet's EES is submitted, do DELP do an initial evaluation of its quality before accepting it for full assessment? For example, if there are issues with the methodology of how certain reports within the EES have been done, would that be picked up from the start and stop the whole assessment from moving forward?
Right, so this is essentially the short answer is yes, in the sense that all of the technical material that's produced for the EES is reviewed by the technical reference group. So if there are fundamental flaws in methodologies of studies, or the wrong model has been used, or something like that, then yes, that is picked up, and that needs to be addressed by the specialists. So that is pretty much of an iterative process, but it culminates then in what I talked about as the authorization review, which is when the proponent says, right, we've listened to everything that we've got back from the community, we've listened to everything from the TRG and the peer reviewers, and here is our complete package. Now, the TRG is not a steering committee, and it's not there to give direction, and some of the things that may come under discussion, such as, well, we could use this model or we could use that one, there isn't necessarily a definitive answer that says this one is okay and that one is not. There may well be a case that different specialists may have different views about the best way of interrogating a particular issue. We're not going to make that call at the authorization stage unless we've got a really strong indication that what the proponent has done is technically unsound or inappropriate or invalid. So there may still be arguments about some of those points at the submission stage and at the hearing stage. That's fine. That's what that process is there to shed light on. But there is absolutely a review by the department and a briefing to the minister before the package goes out for public comment.
Thank you, Jack. So the next question we have is, if we put in a submission, will we have to speak at the hearing, and would it be in person or online?
So if you put in a submission, as I say, you can tick the box to say, I want to be heard, which means that you will turn up at the hearing, but you don't have to do that. Your submission will otherwise be taken account of by the inquiry, reading it and understanding what it is that you've said. But you will miss out on the opportunity to expand on your submission, to perhaps more importantly answer the questions of the inquiry. They're very often greatly assisted by saying, okay, so I've read your submission, you don't need to speak to that again, but I'd like to ask you some questions. So it's up to you. You can do either. In terms of in person, this thing's happening this year. I think we're still going to be still on Zoom or its equivalent. I've not heard any great movement towards anything different. So staring down the barrel of the computer for the balance of the year, I think it'll be online, I would say.
And the only thing I'd add is you can make a submission and you don't have to choose to be heard, but if you don't make a submission, you will not be offered the opportunity to be heard.
Quite.
And in terms of the Planning Panels Victoria will make the judgment, or the inquiry chair will make the judgment about the technology and the logistics. I guess one of the things that's emerged out of the last couple of years is that there is actually some convenience around online submission, online hearings, simply because people don't have to travel. And when you're looking at a project like this that spans, the thick end of a couple of 100 kilometres, the logistics of travelling to get to a hearing being held at a particular point are going to be demanding for some people, whereas sitting in front of the computer at home is something you can do without that extra imposition. But at the end of the day, it will be down to the inquiry chair to determine the actual arrangements.
Thank you. I'm just going to ask a question that's come up in the chat because it's relevant to the question that was just asked. Someone's asked, when submitting, if you tick the box, oh, sorry, I've just missed it. If you tick the box saying you wish to be heard at the hearing, can you later change your mind?
Yes.
Yes.
Yeah, absolutely.
Yeah, but if you don't tick it, then you don't get the opportunity.
You're going to miss out.
Yeah.
I mean, you can still. I've seen people turn up at the directions hearing and say, oh, I didn't want to be heard, but now I do. If it's at the directions hearing, you might be able to scrape in, but don't cause yourself the anxiety. Just tick the box if you think there's any possibility that you wish to be heard. And if in the inquiry, and if you change your mind, that's all to the good. Just let the inquiry know so they can take you out of the timetable.
Thank you. And the next question is, the neighbours in our whole street are very concerned about the project and want to put in objections or submissions. Would it be better and more persuasive if we wrote a single submission together?
The answer to that is generally yes, but you've got to make, because it's just going to assist the inquiry to hear from many people in one document. But you've got to make sure that you're all aligned in your interests. By that, I mean, you may find some people say, oh, well, I'm much more interested in topic A. I don't really care about B and C. So if, on the other hand, you're like, no, everybody is in frantic agreement, A, B, and C, those are our topics and we feel strongly about them and we all feel the same about them, it's fantastic if you can band together in that way. Or you might want to choose to say, all right, we've got 6 people in the neighbourhood. We've got 4 topics. Who's going to do topic A? Who's going to do topic B? And so you therefore split up at least the presentation of the submission according to where people's greater focus might be. But thinking about these sort of things is very helpful to the inquiry and more persuasive.
Yeah, the inquiry is interested in the merits of the argument, not the number of people who are repeating it.
Thank you. That's an important point, I think. Okay, the next question is, does the community get to see any of AusNet's reports that inform the EES before it goes on exhibition? Okay,
so not as a routine part of the process in terms of the actual reports, but we do expect proponents to share information that's emerging from those investigations progressively once it's been reviewed by the TRG. And that's where things like information bulletins and fact sheets and so forth come into the equation. The challenge with the reports is there will be the final versions of those reports published as technical appendices. It can be confusing and distracting if there are earlier versions in circulation at the time that the EES goes on exhibition. So the normal expectation is that those reports be published in full as part of the exhibition package, and the proponent's engagement process should be making that information in broad terms available to the community as it's validated. A lot of these reports go through a really iterative process. and that reflects taking into account the information that's being gathered, the comments from stakeholders. Some of the reports feed into each other, and therefore comments on one report may then need to be reflected in an update of another report that relies on that earlier one. So it is an iterative process, and therefore all of these reports will go through multiple versions. It's much better, I believe, for clarity and for simplicity that we don't have the confusion of multiple versions of reports being compared and potentially creating confusion. But we do expect the proponent to be sharing the key messages that are emerging out of those studies.
Yeah. Putting on my evil barristorial hat for a moment, there can often be some very interesting and revealing, at times, revealing matters that can be uncovered in delving into the treasure trove of previous drafts of things. So you might want to think about when you're preparing, if you get a sniff of change of opinion, you want to know a little bit more as to why that might have happened, you might want to think about whether you're going to go for a little fossick. I'll leave it there.
Thank you. Okay, the next question is, what would be the best way to put together the submission if you have more than one issue or concern you want to talk about? Is it better to focus on one thing or try to cover everything?
Yeah, it's Jack's point again, isn't it? And it was one well made, which is don't bury the lead. You know how in journalism they say don't bury the lead, if that's understandable in my heavy Scottish brogue. So you're going to confuse the reader if you've got this great point and you've confused it all with various other smaller points. So be very clear on what you regard your big ticket items to be and make those points clearly and briefly.
That's cool.
Great. So the next question is, will the outcome end up just being whatever costs the least? Is economics one of the things that are considered by the EES process?
Okay, so in terms of the EES process, the final outcome of the EES process is the Minister's assessment of environmental effects as advice to the proponent and to the statutory decision makers. Environment, including the ministerial guidelines on page 2, there's a definition of environment which basically talks about human surroundings and includes economic, social, cultural, heritage, as well as the biophysical environment. So in that sense, economics, yes, that is part of the environmental assessment and part of what's considered. There's more to economics than just the cost of the project, though. Cost may be one of the factors that contributes to the evaluation of feasibility in terms of alternatives that are feasible and could deliver better environmental outcomes. So if something is prohibitive in terms of cost, then that may impact on its feasibility as an actual deliverable solution to a problem. But in terms of economics, it is within the scope of the EES, but it looks at broader economic things, so things like employment, things like positive and negative impacts of a project on the on other businesses or other industry sectors. That's sort of the general focus of an economics assessment.
Yeah, there'll be consideration of the question of net community benefits, and that will include a consideration of economic benefits. As Jack has just indicated, you might well hear terms such as agglomerated benefits start to float around in terms of the ripple effect of any benefits. So yeah, it will be taken account of in that way.
Thank you both. So the next question is, will the state government be getting a second opinion on any of AusNet's reports?
Right. All of the technical reports that the proponent's consultant team produces will be reviewed by the technical reference group. which is made up of government authorities and statutory decision makers who have expertise in those relevant areas. So they'll be reviewed by the TRG in the context of the methodologies, the data sets, the data sets that have been used, the alignment of the work with statutory requirements and standards and so forth. So that will happen to every study will be reviewed by the TRG, and we will review the proponents' consultant team's responses to TRG comments as part of the adequacy review process. AusNet has also advised of its intention to appoint independent peer reviewers for several of its specialist studies, and that is quite a common thing for a proponent to do in an EES process. And in addition, DELP is looking at appointing peer reviewers for a couple of the key studies. So there will be an additional level of technical review of the intention at the moment is for that to be done for the undergrounding report and for the agriculture report. So there's a process that we have to go through to get to the procurement of specialists to do those peer reviews, but it's quite a multi-level review process that all this work will be put through before it goes out as part of an exhibited EES.
Catherine, I think there's a related question in the Q&A about can a submitter engage an expert witness for the hearing? May I address that now? Yes, you can, but listen to what Jack said. So there's a whole process involved with technical experts and now the peer review. And so if you want an expert, you need to get one quickly because you'll start to run into, oh, I'm conflicted, I'm already engaged, and that's a real issue. So if you are going to call an expert, yes, you absolutely can bring expert evidence. That expert evidence will be questioned. You yourself will not be, but get in there early.
Thank you. That's a very important point. Okay, next question is, how long will we have to speak at the hearing to talk about our concerns?
So,
short, brief, to the point, as long as it takes, but don't repeat yourself.
You'll be asked to indicate how much time you would like, and you may get all that you ask for, but the inquiry may want to try and manage things more directly than that, but you will be given a time period, and as Louise said, if you've asked for 10 minutes, don't expect to be allowed to speak for half an hour, because you'll be if you've been given 10 minutes, there will be somebody scheduled to come on at the end of your 10 minutes.
Yeah, so for example, sorry, Jack.
Yeah, so the inquiry needs to try and manage it logistically, and the logistics of running a hearing like this are, not to be underestimated.
Indeed. So if you want an example of that, if you go on to Engage and you look at the suburban rail that's happening at the moment that Jack made mention of before, and you click on the timetable, you'll see that many of the individual submitters are towards the end of the hearing, and there's like 10, 15 of them in any one day. And so you've got 5-minute slots, 10-minute slots, 20-minute slots. But you can imagine, as Jack says, if you start to get people not adhering to their time, it all goes to pot pretty quickly. So to give you an indication of how that might be managed, the timetable on Suburban Rail is up there for you to have a look at.
Thank you. So the next question is, what is the usual time frame for when the EES is submitted to when it goes on exhibition and then a recommendation is made?
Yeah, there's a bit to be got through. I'll go through very quickly. Once the proponent delivers a final draft complete package for the authorisation review, from the point where that lands with us to the point where exhibition can commence is probably of the order of about 6 weeks. Exhibition, as we've said, has been specified as 30 business days, so that equates to 6 weeks plus public holidays, if there's anything like that in there. Directions hearings usually 3 to 4 weeks after the end of exhibition. The public hearing starts another 3 to 4 weeks after the directions hearing. The big piece of string in this is the length of the duration of the actual hearing, because that will be a function of the matters raised in submissions and the number of submitters and parties who wish to be heard. But recent hearings for major EESs have taken of the order of 8 to 10 weeks. The inquiry is given a period specified in its terms of reference within which it should write its report and deliver that to the Minister after the last day of hearings. It's usually of the order of 6 to 8 weeks. And the ministerial guidelines say that the Minister will normally make his assessment within 25 business days of receiving the inquiry report. So if you add those up, from the point where the authorisation draft lands with us to the point where the Minister can make an assessment, round about 9 months. Roundabout. But because there are a few things in there that are a little bit flexible, it can be a bit longer, it can be a bit shorter. It might depend on whether there's a Christmas holiday period that's in that and where it lands. We have a state election coming up later this year, which includes the lead up to that is referred to as the caretaker period. That can have an impact on timing as well. So there's a number of factors that will play out in terms of the actual duration, but and the point that probably matters most for potential submitters is the duration from the point where the EES goes on exhibition to the point where the Minister makes an assessment, and that would normally be of the order of 6 to 7 months. So that's the sort of quantum you'd be looking at.
Thank you very much. We've got one more question that was submitted in advance, and then we'll move on to the live Q&A for anything that we haven't already answered. So the last one was, this individual is concerned about the anticipated decline in property value or complete loss of value of residential land due to hosting an easement or potentially being a property with neighbouring or immediate vicinity in the immediate vicinity to a transmission tower. And so the question is this the kind of thing that would be assessed in the EES and or the planning scheme amendment? And does one make a submission to one of these processes or potentially both of these processes?
So I'll do the last one first. The short answer is that a single submission on the EES can address any of the statutory approvals that are coordinated with the EES. So if there is a draft planning scheme amendment as an attachment to the EES, then a single submission will be treated as a submission on both of those, and it can address both of those. In terms of EES and the notion of values, I guess the focus is on the Environment Effects Act is about effects on the environment. Effects on the environment potentially may translate into impacts on property value. Well, there may be arguments about that, but the focus is really what are those things that you're concerned about? Is it impacts on landscape? Is it impacts on noise, other amenity, whatever? Those are the things that the EES process is there to interrogate. Where a proponent is seeking to acquire a tenure interest over land in the form of a freehold acquisition or an easement, then there are financial implications associated with that. They're managed under the Land Acquisition and Compensation Act, and they may well involve the appointment of qualified valuers to arrive at the right numbers, but that would only apply in the context of an actual acquisition or acquisition of an entitlement. Louise, you probably got better words than me for that stuff.
No, that's all good, Jack. So yeah, the bottom line is that the effect of a proposal on the land value of a person is not what's called a relevant planning consideration. So a project's not stopped because it will diminish the value of your land, to put it in the bluntest of terms. However, if the project requires to buy your land or take an interest in your land to allow the proposal to go ahead, so getting the land for that public purpose of the project by way of an easement or buying the land outright, yes, that's when the act that Jack referred to, LACA for short, is engaged, and there's a whole process then of notice of acquisition being sent out, then the first offer of compensation, and you have plenty of time to respond to that offer of compensation, often with your own valuation. But it is a separate process. It's not a planning consideration. Rather, it's said that if the project happens and land is needed to be acquired or an easement taken over the land, then that's when LACA comes into play, and then there's a whole process of notices and responses then to the compensation offer.
Thank you very much. That wraps up the questions that we've received in advance of the session. So I'll just have a look through the chat and we'll start with those that came in first. So this person was happy that their question had been answered in your presentation, Jack, but it was around what's the minimum time the EES is usually exhibited for, which is 30. In this instance, it'll be 30 business days or 6 weeks. So the next question was about submitting a video, and I think you answered that, Louise, in that yes, you can.
Yep.
Or can they only provide a link? No, you can attach the video. And how can, so sorry, the second part of the question is, if so, how can the submitter be sure that the video will be watched by the panel?
Yeah, the panel's required to look and consider all submissions and materials referred to therein. That's their duty. They will look at it. If you're attending at the hearing, you might seek permission at the directions hearing. Look, I want to actually play my video, and so Planning Panels Victoria will help you with the whole screen sharing business. There's likely to be an electronic book that's all the materials in before the inquiry that you'll then just click on and screen share. So you'll be guided through all that process.
Great, thank you. So the next question is, what about impacts to business and industry? How is that covered in acceptable environmental impacts, and how is that addressed by the Minister?
So yeah, impact on, and that comes under that sort of broader area of economics. So projects can have positive and negative economic impacts. They may generate employment, which may be seen as a positive impact. They may affect the operations or businesses that are already in place. So those are all legitimately part of the environment for the purposes of the EES. There are some points in the scoping requirements that deal specifically with economics, and there will be an a technical economics report as part of this EES, and that will inform the main report. So that is absolutely legitimately part of the environment for the purposes of the EES process.
Thank you, Jack. So this question was answered, can a submitter engage an expert witness for the hearing? The answer to that was absolutely yes, but please get in early, because a lot of the, especially the highly specialised consultants may be already engaged by various parties involved. So you may find that everyone that you approach has a conflict of interest, so best to get in early. The next question was about ticking the box to make sure you have an opportunity to be heard, which was answered. Yes, you can later change your mind. And this was a question that came in relation to that other previous question about DELP engaging peer reviewers. Are these independently appointed by DELP or AusNet? I think you sort of half answered that before, Jack, but if you wouldn't mind.
Where the proponent chooses to engage peer reviewers, the proponent's responsible for that engagement. generally there will be conversations at the TRG around the scope of that peer review and the way it ought to be set up. But that's, you know, the proponent is responsible for preparing the statement, and to the extent that appointing a peer reviewer is a helpful way of contributing to the proponent being able to prepare a better statement, it sits within the proponent's range. In certain cases, and we've done this on a number of occasions in the past, DELP has itself appointed peer reviewers for particular issues, generally issues that are of significant concern to stakeholders or that have particular technical challenges around them that need some better illumination or at least a higher level of confidence that the work which is being presented in the EES is the best possible work. So in those cases, and the ones I mentioned, undergrounding and agriculture, those appointments will be made by DELP in accordance with DELP procedures and procurement processes, and those specialists will be overseen by DELP. But what they will be doing is providing advice and commentary that the proponent's primary consultants will have to address. Doesn't necessarily follow that they'll agree with everything that the peer reviewer says, and peer reviewers are just that, they're peer reviewers, they're not superior reviewers. They're not there to tell the proponent specialist what they must do. They're there to say, yes, this looks like you've done it the way that it ought to be done. Have you thought about this other way of doing things? It's really an opportunity to try and make sure that the primary consultant and the final report that the primary consultant produces is the best report that it can be.
Thank you. The next question is, given that benefits will be discussed by the proponent, would it be correct to assume that disbenefits are most likely to be discussed by the submitters?
No, I wouldn't assume that. And often, okay, it goes back to that question of what's persuasive. It's often most persuasive if you say, look, I acknowledge. So if you have concerns about A and B, I acknowledge that the proposal deals well with and is a benefit in the following way. However, so a submission, I think in my submission, oh, here we go. Sorry, forgotten not in court. What I say is that a submission is at its most persuasive when it acknowledges, look, of course, there are some good things about this proposal, and they're A, B, and C. However, here's my concern. So shows balance. It's very persuasive. But yes, the proponent will have to grapple with the pros and the cons here in order to give the inquiry the best information. And as a submitter, you can do what you like, but I just say that if you want to be as persuasive as you want to be, acknowledging that, yes, there are some good things about this proposal will always set the listener up to, oh, okay, this is a balanced approach. Let's see, there might be a bit more leaning in, if you will.
And we would certainly expect that the EES will objectively acknowledge adverse effects as well as benefits.
Thank you very much. So the next question is, this was in relation to the discussion we were having earlier about the timing of the whole process from when the EES is received to when an assessment is made by the minister. So with that timing in mind, is it likely that the decision would be made after the election?
Well, if they're referring to the minister's assessment, then that's at the end of the process, and that timeline that I laid out as, you know, of multiple months is yet to start. So yes, that's possible. There will still be a Minister for Planning after the election. We don't know who that person will be, but there will be a Minister for Planning, and that Minister for Planning will have responsibilities for assessments under the Environment Effects Act. So There are, I think, at the moment, somewhere in excess of 15 or 16 EESs in preparation. Quite a few of those are likely to not have completed the process before the election. So that's, and past elections, it's been the same, that there have been EESs which have been in preparation for which the assessment has been made by the minister in the portfolio after the election. So that's common and the process can deal with it.
Thank you, Jack. The next question is in relation to that earlier discussion around land devaluation. So the question is, if land devaluation leads to economic impact on municipal rates, is that addressed in the EES and the inquiry? And is that sort of economic impact included in the minister's scoping requirements?
Well, the scoping requirements are there, and I haven't got them open in front of me at the moment, but I think it's section 4.4 or 4.5 is thereabouts is the section that talks about socio-economic issues. So the scoping, you'd have to look at the scoping requirements to see what they say. It's an interesting sort of extension of effects, I guess. And I can't give a definitive answer about how that might be addressed in this particular case. I can't recall another EES that's addressed that sort of issue in that manner, but that's, you know, I would need to go and have a look to see whether I've got any better information than that. I'm happy to take that one on notice and see what else I can find out.
There's only one general point I'd like to make in response to that question, Catherine, which is that in terms of an assessment of the planning scheme amendment portion of the proposal before the inquiry, and we assume that there will be one, in order for the inquiry to take account of such an impact as rates and such, the inquiry has to be persuaded that what it's seeing is not an impact on one individual or two individuals or more. It needs to say that what it amounts to is a social impact on society more generally. So that's why I'm interested in this concept of municipal rates. I mean, I don't give a definitive view on it, but what you need to be looking through is the lens of, this is not just a social impact on me because I have to pay more or I have less value in my property, but rather that the proposal will result in a impact to society more broadly, and that will get you under the bucket of social impact.
Thank you, that was very helpful. The person who asked that question, I will get in touch with you offline to see if Jack can provide any further information that might help you. But that was the last of our questions, and we've very coincidentally lined up with the allotted time frame, which was to finish at 7:30. So on that note, we will wrap it up here, and I'd just like to thank you, Louise and Jack, for joining us this evening, and thank you to the members of our community who have tuned in to tonight's session and contributed to the discussion. I think there were some really fabulous questions that came through. A recording of this session will be made available on our website in the coming days. And if you have any suggestions on topics or agencies that you would like to hear from in relation to the Transmission Network project for Western Victoria, please feel free to send us your ideas. I've just popped the link up so that you can submit those if you wish to. And on that note, thank you everyone again for joining us. We really hope you found the session valuable. Have a great evening.
Thank you.